Welcome back. As you know, my name is Brian Burkhoff, and this is the New Jersey Workers' Compensation Conversation. Today, we'll be talking about how to handle a reopener application of a prior order approving settlement. When a case resolves via an OAS, the petitioner has the right to reopen that claim within 2 years of the last benefit they receive. This benefit can either be a check for their permanency award or medical treatment that is provided by the respondent. But after that 2-year period, they are barred from reopening that claim by the statute of limitations. A major issue in reopener is exactly that, if the statute of limitation applies. We must ensure that it has not run. It's easy enough to determine if the statute of limitations has run by calculating 2 years from the last permanency check that petitioner received. But there's more difficulty when figuring out the 2 years after their last medical treatment. Let me pose a question. Should the 2 years start running from the date that the last treatment occurred or the date that the bill for that was actually paid? This is an issue that has been addressed by the appellate division. So, what happens when the statute of limitations appears to have run, but the employer makes a medical payment at some point beyond the 2 years from the statute? Does that revive these 2 years and give petitioner additional time to reopen their claim? In this specific case, there was an injury in 1942, and lingering treatment bills were paid 2 years after the date of last benefit paid to petitioner. So, the petitioner was arguing that the 2-year statute of limitations was revived and they had additional time to reopen the claim. However, the respondent specifically reserved their right to the defense of statute of limitations when they agreed to pay these bills. So when the appellate division heard this case, they made the determination that it was properly dismissed as the statute of limitations had run. The lesson in this case is that when an employer is debating whether or not to pay a bill that has lingered far past the resolution of the claim, always ensure that you reserve your defense to the statute of limitations to prevent a claim from being reopened when we thought it was permanently put to bed. Now, let's move on to another key issue that we face in reopeners. When they're filed, the first issue is often determining whether or not we need to provide additional treatment. Often, the petitioner, in filing the reopener application, will make a request to return to the doctor that they previously saw, but that's not always the case. Before we determine if we're going to send the petitioner to a doctor, we need to do some investigation. Specifically, we want to know, what has petitioner been doing since the case last settled, especially if it's been a long time since the last award? Are they still working for us, or have they moved on to a different employer that may be involving physical labor? Have they had any new accidents? Have they had any new treatment on an unauthorized basis that we're unaware of? We also are entitled to get answers to interrogatories from the petitioner when they file these reopener applications. This will provide us with the information to ensure that we're able to send the doctor a full picture as to what has occurred since the last time this case settled. Once we have all this information, we have to determine whether or not petitioner is actually looking for more treatment and whether their complaints are serious. Sometimes we face what's called a calendar reopener. Petitioners see that 18 months has passed, 20 months has passed, or even getting right up to the 24-month mark since their last benefit was paid, and they determine, I'm going to file a reopener because I'm looking for more money, even if my condition hasn't really worsened. So we have to try to make a judgment call as to whether or not there is a true need for treatment, which often there is, and you'll see that when petitioner has quickly reopened the case, even while they're still receiving permanency checks. If they're receiving checks and they're making a request for additional treatment, it's often safe to say that the petitioner is in a spot where they should be evaluated with a doctor. So, once we've done all of our investigation to determine what's happened to petitioners since the last settlement, we can then send them back to one of our qualified IME experts to address many of these points and determine if there has been a causally related change in their condition. If so, they'll provide the appropriate treatment, and if not, they'll discharge them and state that they continue to be at MMI as previously noted. But overall, treatment seems to be the main issues that we deal with in reopeners. And once the treatment is resolved, we can then move to the issue of permanency. You might ask yourself, how do we value permanency in reopener claims? Well, in Section 27 of the statute, the Supreme Court has said a petitioner can recover additional compensation for an increased incapacity when they can show that this increased incapacity is causally related to the original accident. So, how does the petitioner prove an increase in incapacity? The Appellate Division has specifically stated that the petitioner must show a substantial worsening by objective medical evidence. So that's the standard that we're going to be looking for. A substantial worsening by objective medical evidence. And we've discussed in previous videos what would satisfy those qualifications. So let's provide a fact pattern for a hypothetical. Let's say the petitioner has a prior award of 65% of partial total for the back, and he's arguing for an increased award on his reopener. What information would you want to know before deciding if we need to pay an increase in this amount? I would want to see if there's been any updated diagnostic testings or other objective proofs that we can review. If there's been an updated MRI that has showed a worsening at the levels we paid for, and our authorized doctor has confirmed that that worsening is related to a degeneration from our accident or overall is causally related to our accident, then we might have to be paying an increase on an OAS in that case. However, in this case, let's say that the petitioner's doctor believes his disability has increased to 90%. However, the MRI doesn't show any worsening whatsoever. Should petitioner get an increase in the award in that case? Absolutely not. We would seek a Section 20 to close the claim out permanently, or potentially a dismissal based on the case, and have a full trial on the issue. When we're trying to determine whether there has been objective proof of a worsening, sometimes petitioners rely on their range of motion. They'll argue that my shoulder is not able to move as well as it did at the time the case settled previously. However, it's our stance that range of motion is not an objective proof of a worsening or objective proof of any disability. The Supreme Court actually has said that it is subjective because it cannot be definitively confirmed. Range of motion, as quoted by the Supreme Court, will not satisfy demonstrable objective medical evidence and the standard required to support an award of partial total disability. They made this decision by reasoning that most range of motion tests are subjective respondents by petitioner. So if there is no other objective evidence to rely on other than the range of motion test, for example, an MRI or an X-ray, we are in a strong spot to argue that there is no objective proof and petitioner should not be entitled to an increase on an OAS, but rather should obtain a Section 20 settlement, or we would proceed to trial, depending on the situation. So to summarize, when handling reopener applications, you first want to ensure that the statute of limitations has not run, and if it has, we want to file a motion to dismiss immediately. Second, you want to investigate what has changed since the last time we settled this case in petitioner's condition, his employment, and any other factors that may impact causal relationship. Third, once we've done our investigation, we want to schedule an IME with one of our qualified medical experts and ensure that they have been provided all the information we obtained during our investigation. And finally, once treatment has concluded, we want to ensure that we're only paying for an increase in disability when petitioner has met the standards as outlined by the Supreme Court and the workers' compensation statute. Otherwise, we're going to be pushing for a Section 20 settlement or a complete dismissal. If you have any questions about the topic that we talked about today, please feel free to reach out to me. I'm happy to address your question privately or in an upcoming video. And with that, I hope you have enjoyed our compensation conversation, and I look forward to speaking again soon.